Welcome to Learn Law Better. Do you wonder what goes through the mind of a professor when they grade an exam? Stay to the end as I go through a negligence essay final explaining what I am thinking as I read the essay. Don't forget to hit the like button if you enjoy the episode, and please click the subscribe button and the bell if you don't want to miss any future episodes. Hi, this is Bo Buys, and today I want to walk you through, line by line, a final exam I gave to my students a few years ago. Before I forget, a shout out to Steve for suggesting that I make this episode. Let's begin with an essay question I gave to my students a couple of years ago. So with any essay question, you always start down here with the call to question, discuss all issues related to a lawsuit brought by museum to recover the $200,000 in damages. Do not discuss any intentional torts. You always start with the call to question because then you get some clues. Here we know not to think about intentional torts, and we know that the plaintiff is going to be the museum. So with that, let's go and read the rest of the essay question. Sam is an employee for the Washington Post newspaper. He was sent by the Post to City to cover one of the presidential debates. The debate was scheduled on a Friday from 8 to 10 p.m., but Sam noticed that museum, 3 blocks from the presidential debate site, was exhibiting a large collection of original sketches by noted artist John James Audubon. The exhibit was on Friday from 7 to 10 p.m. Sam came up with a plan to walk 1 block from the hotel to the museum, rush through the museum in about 20 minutes, and then get to the debate by 7:30 p.m. On Friday, as planned, Sam walked over to the museum to see the exhibit. He entered the museum as it opened at 7, began to walk around. At 7:15 p.m., while on the second floor of the museum, Sam noticed a wide brass handrail along the stairwell that appeared to go down at a gentle slope to the first floor. Sam had always wanted to slide down a rail like this, so he looked around and noticed that there was no one looking. Then he slid around the rail, but the rail was much slicker than he thought, and as he got to the first floor, he tumbled about 15 feet past the stairs right into a James Audubon painting, causing $200,000 in damages to the painting. Now, in this exam, I was looking for 3 things: Sam's negligence, vicarious liability through respondeat superior, and a discussion of frolic versus detour. So with that, let's look at a student answer that I haven't looked at since I graded several years ago. So what I'm going to do here is I'm just going to tell you what's going through my mind, what I'm thinking point by point, any issues I see as I'm reading through this. So let's see how the student starts. The issue is whether the museum has a cause of action for negligence against Sam. Great. Immediately I know the party, the plaintiff, the defendant, and the cause of action, which is negligence. Negligence is a tort dealing with the unreasonable conduct of the plaintiff, which results in damage to the plaintiff. In order to establish a prima facie case, they must prove, duty, breach, causation. Great. It's all there. Great opening statement. I now know the parties, the tort, the main issues. Remember, when I'm grading, I sort of divide my mind. Half of me, I'm reading this as a person who doesn't know the law or the facts. So everything I'm going to learn about Sam, the museum, etc., has to be explained to me in this paper. If it's not explained here, it doesn't exist. The other half of my mind is sort of peering down on me, with the rules and the law, understanding what's going on, so I can appropriately grade the exam. But that's a great opening section. Good. Duty. Duty is the first element. And now I'm just going to be kind of reading like the way I would normally read. I'm not going to just read everything verbatim because that's not how I do it. Requires legally recognized relationship. Yep, that looks good. Warranting the defendant's found. Yep, it's fine. Because that's really what I'm doing. I'm kind of going in my mind through a checklist. Okay, so duty, what's the rule for duty? We've got some analysis here. Excellent. Here, Sam is a lawful visitor of the museum, so he's an invitee. Therefore, he has a duty to the museum as a guest. So one of the things that we need to think about when we're doing this, so I'm going, well, wait a second. The rules, for trespasser, invitee, and licensee, those are the duties owed by the landowner, not by the person visiting or on the land. So the student here has a little bit of confusing Confusion, yes, he's an invitee, but that's irrelevant because we're going to look at what he did wrong, not what the landowner did wrong. So we'll keep reading, but already I see there's a little bit of confusion here concerning the duties owed by the landowner. His duty is going to be one of reasonable care, regardless. So let's see. So he has a duty to the museum as a guest, although Sam only intended to see the museum until the presidential debate started. It's irrelevant. As a general rule, the person has a duty to act as a reasonably prudent person. There we go. That's really the right standard, is to act reasonably. Sam is in no exception. Good. So his duty is to act reasonably. Now let's see if he breached his duty. Second element, breach, fails to meet the standard of care. Good. All right. Can be determined by direct evidence or circumstantial. That's irrelevant. I mean, here we have direct evidence. We know how the thing broke. So this whole idea of it's too much. I mean, it's not wrong, but I'm just ignoring it because it's just not relevant for what I'm looking for. An inference, again, it's irrelevant. I don't care about inferences here. In this case, Sam saw a handrail going from the second floor to the first floor and decided to slide down the rail. Small typo. I kind of ignore that. If I start seeing more typos, I start paying attention. The occasional typo, it just doesn't matter. This is not reasonable for someone to do in a business establishment. So why? I need to know why. The student didn't go enough. Did he just start with causation? Okay, they moved to causation. So here, remember, for breach of conduct we talked about, or breach of duty, you should have discussed a little bit about, a little bit deeper. You could have used a sort of a cost-benefit analysis like you saw in the Learned Hand case, right? The U.S. Versus Carroll towing, where it's P is less than P times L. I mean, you don't need to have that formula, but you have to have the thought process behind it. That, yes, it's a business. You have expensive paintings. The likelihood of something breaking is really high. It's just not what's done, right? There need to be a little bit more here. This is too much of a conclusion, not enough analysis under breach of duty. We really need to know why he did not. I don't think you needed much more, but you needed a little bit more than what this student provided. All right, actual cause, third element, good. Proving the defendant's culpable was the factual cause. There are two tests. You don't need to list both tests. In fact, by listing them, you start creating some confusion in my mind because you only use one or the other. But let's see what he does. The but-for test, substantial factor. If there's only one defendant and cause, the but-for test is used. If there are multiple, great. Oh, good. So they've just been very thorough. Probably didn't need to, but sometimes it's just better to be more careful. I'm not marking them down for being overly cautious, but on a timed exam, you always have to think about what do you really need. Here, Sam is the only reason that the painting was broken. Therefore, the but-for test is appropriate. But for Sam sliding down the handrail and falling into the painting would not have been destroyed. Good. That's a great but-for paragraph. Proximate cause is the fourth element, deals with foreseeability. In order for a defendant to be the proximate cause, required that their conduct not be too attenuated in order to constitute liability. 3 tests. Boy, this is going way deeper than is necessary for proximate cause. Keep in mind that when something is obviously the proximate cause, you only really talk about proximate cause in detail when something is unforeseeable. When something is clearly foreseeable, you just need 4 or 5 sentences and you move on. So I already see here the student has gone way. They really don't understand how it works. That's fine. They're kind of just working through each of the foreseeable aspects. Foreseeable plaintiff, and at this point I'm just skipping because this is just sort of irrelevant. Foreseeable type of harm. Okay, he's mentioning a few things here. That's fine. And there are, of course, no superseding intervening forces. That's just irrelevant. You're just losing time. The student lost 4 or 5 minutes. This just was not necessary. Just a few sentences explaining foreseeability and moving on. Damages, because as you see the design of the exam, it's really pushing you towards vicarious liability. The negligence is very obvious. You just needed something for each of the elements and then moving to the real issue, which is going to be respondeat superior and frolic and detour. But let's keep going. Damages, 5th category, as long as they are reasonable. Suing for the painting, $200,000. While large, it's provable. Bingo. Okay, good. This was a good basic negligence paragraph, or essay, other than breach of duty. There should have been a little bit more there. Now let's move on to vicarious liability. Let's see what the student says. All right, let's start talking about vicarious liability. Let's see, the issue is whether the Post newspaper will be liable for Sam's negligence when he acted negligently and destroyed the museum's painting. Generally a good statement. The problem is I, as a reader, don't know who this Post newspaper is and why they would be liable for Sam's negligence. So hopefully very quickly the student will explain that to me, because at this point I don't know who they are. Probably should have put something whether Sam's employer, the Post newspaper, will be liable for his negligence. Something that explains to the reader what's going on. Let's keep going. Vicarious liability is a form of liability in which an employer can be made liable for the tortious acts of their employees, yes, if they are acting within the scope of their employment. The scope of employment is a crucial aspect of this tort. Requires an employee not deviate substantially from the work for personal reasons, which would be considered a frolic. Frolics negate an employee's vicarious liability. However, if an employee only deviates slightly for a reasonable amount of time for personal purposes, then this is classified as a detour and the employer is still liable. So the student here is sort of conflating two concepts. You have respondeat superior as one concept, and then frolic and detour being sort of an exception to the rule. Would have been better for the student to have broken both of these out. I think what we're going to see is both discussions sort of mixed together, which I think is going to make it a weaker answer. Could have been stronger. Remember, anytime you have a separate, distinct legal concept, even though related to something else, talk about it separately. All right, here Sam is an employee of the Post newspaper and assigned a job of covering. Okay, so now the student has sort of left the IRAC format. If we're talking about respondeat superior, I would expect the first issue in a respondeat superior is determining whether he's an employee, then sort of going into it. I'm just getting narrative here. It was on Friday, 8 to 10, museum 7 to 10. Boy, these are coming right out of the facts, but not being tied to any legal concept. So this is really a narrative. I'm not sure why it's here. It's not connected, but let's keep this kind of going down. This was Sam's decision, all from the facts. I mean, again, they need to be in the essay, but you have to explain why the facts are there, why they're relevant. Okay, so he's just quoting from the question. Okay, so here we go. We get to our own. Was not quite a deviation from his work that his employer would expect of him. Certain things are expected deviations, taking breaks for food, restroom. However, the museum is not one of them. Therefore, it's likely that Sam's trip to the museum would be viewed as a frolic, thus eliminating the Post liability. In conclusion, it's unlikely that the museum will be successful in a cause of action for vicarious liability against the Post. So the student just sort of asserted here Sam's an employee, never ties it to respondeat superior. Again, it wasn't lengthy, didn't have to be lengthy, just explain the rule that it applies when an employee is acting within the scope of their employment. Sam was sent down there, he was an employee, and he was there to cover a job. So he was in the city based on his employer's business. And then go into the frolic and detour. And actually, I didn't care which way you went on this. I mean, you could have argued that it was a frolic or a detour. I didn't care. But you did have to tie it in a little bit better than what's going on here. So it's okay. It's all there. It's sort of jumbled. Could have been much, because the student was sort of combining both concepts together. All right, let's see what else he does. Goes into comparative negligence. There is no comparative negligence here, right? Not being tested, so the student was just trying to be overly careful. I ignore these things. I don't take points off, so I'm just kind of scrolling, just wasted time. What else here? Yeah, none of that was that. So the whole affirmative defense was irrelevant. I mean, I kind of look through them sometimes to see if I missed an issue, but here I don't think this is a valid affirmative defense. So anyway, that is this essay. So once I do that, and by the way, I'll show you very quickly my grading sheet. Grading sheets are going to vary from professor to professor. So here's mine. I tend to be very careful in my grading. A lot of people just give points. I kind of go through here. Here you'll see the elements. If they were available, then I sort of check off one of these boxes and those equate to points. Here's my analysis, the kind of discussion I was looking for. And I'll actually have this open while I'm grading, and I'll check off these boxes. And then you'll see the spreadsheet over here on the right. Certain points are given depending on which box I check off. I grade for organization, so that's important to me. If it's well organized, not so well organized, and again, you get different points. I'll just click on one of these boxes, and that equals different points here. Again, that's going to vary from prof to prof. And then same thing, respondeat superior. Here's the rule statement. That allows me to stay focused and to know what rule I'm looking for, the facts I'm looking for, conclusions I'm looking for. And by the way, if a student makes a good case different from mine, they still get the points. This is just sort of my initial reaction, what I think students should write. If a student goes in a different direction, but they're accurate, they of course get full points for their writing. And there's frolic and detour. There are the rule statements, the facts, and then a conclusion. I thought this was more of a detour, not a frolic. But again, if the student made the other case, that was fine too. They just had to be convincing. All right, that is this essay question. If you enjoyed this material, hit the like button. Also, to avoid missing any future episodes, hit the subscribe and bell buttons. For more resources to help you get ahead, including my blog and newsletter, check out learnlawbetter.com. Thanks for watching.